Well, we're going to turn now to some new research exploring how drug and alcohol impairment impacts the rights of defendants. To talk about it, I'm joined by a lead researcher on a new project that looked at this very issue, Jacqueline Evans. She's the director of the Legal Psychology Graduate Program at Florida International University in Miami. Good morning, Jacqueline. Thanks for being here.
Good morning. Thank you so much for having me, especially on a day that is a very Florida day during hurricane season.
It is a very Florida day, and hopefully you're safe down in Miami. It looks like that's a better place to be than some. I'm also
Definitely.
joined by DUI criminal defense attorney Susan Cohen. Good morning, Susan.
Good morning.
And retired federal law enforcement officer and safety analyst Mark Baughman. Good morning, Mark.
Morning, Ann.
So, Jacqueline, let's start, if we can, with your research. We'll get into the details of the study, but broadly speaking, what did you find?
So our most recent project was looking at the impact of intoxication when somebody is undergoing an interrogation. And overall, we didn't find a statistically significant effect suggesting that intoxicated people were more vulnerable, but we did find they were highly likely to say something that was suggestive or would be seen as suspicious by somebody questioning them. And we also found that while we had only a few false confessions across our study, all of them were people who were intoxicated at the time.
And so we know generally that intoxication can impair a suspect's comprehension, or really anyone's comprehension. Um,
Mhm.
and also that intoxicated suspects are believed to be likelier to make incriminating statements, even if they're innocent.
That was what we were predicting to find. Absolutely. Like I said, we didn't find statistically significant results in that direction, but the overall trend did support that.
So, what prompted you to look at this topic in the first place?
Well, the trajectory of my research actually started almost exactly 20 years ago. My very first semester of graduate school, I proposed a study. That one was looking at the impact of intoxication on a witness to a crime, and then started doing research in the area of witnesses who were intoxicated for several years. And then as my career developed, I sort of transitioned more to looking at interrogations instead of witness interviews. And so naturally, my interest in intoxication also kind of headed in that direction.
So, Susan Cohen, why is this kind of research important? What are the implications?
Well, anytime you have a defendant waiving their right, any of their rights, but particularly their right to counsel, one of the underlying things that has to be determined by the court is that it was knowingly and voluntarily waived. And so the question is whether or not they were capable of making that kind of waiver if they were intoxicated. And I think you do, though, have to make a distinction between DUI cases and other types of criminal cases. In most cases, in a DUI case, in terms of the argument of whether they're being intoxicated would make them unable to waive their rights, puts everybody in an awkward position because the defendant either has to argue they were impaired so they couldn't waive their right, or the state has to argue they weren't impaired, which goes against the grain. And normally it would be done in a pretrial hearing. The main times we run into that on a DUI is going to be if the person is not in the car. And we have had cases, I know that it's not a statistical study, but we have had cases where people were not the driver who admitted to being the driver. And only later we were able to actually show that even though they had pled guilty to the charge, they were not the person who was driving at the time. So it has a lot of implications as far as that goes. But I think the bigger implication is sometimes even a DUI stop leads to other types of charges. And so once you get into that, you're going to have a more intensive interrogation. And then I think it becomes a bigger factor.
And you were saying to me before the program that in terms of like a Miranda right type situation where someone is being informed of their right to remain silent and to have an attorney present and all of that, that typically doesn't come into play at the beginning of a DUI stop. That there's very often this is happening outside of an interrogation room
Correct.
prior to a kind of a required formal reading of someone's rights.
Well, what happens is at the initial part of the stop, there's going to be some questions asked and there's going to be discussion. But your rights under Miranda begin and the necessity to warn somebody of those rights apply only to custodial interrogation. So, one, you have to be in custody, and two, the officer has to be questioning you. So anything you just voluntarily say where there's no questions is admissible and unrelated to this issue. I mean, you may be impaired and you may offer information, but that's a whole different situation. Also, custody. So on a DUI, where that degree of custody that requires the Miranda is constantly moving. There are some aspects of the DUI investigation that Miranda warnings are given when you have to give verbal responses. And it depends, it's generally later on into the investigation, but you're right, it's not in an interrogation room. So it's a little bit different under those circumstances. If they were to interrogate you once you're in cuffs and you're in the back of the car, then clearly that's a Miranda situation. But there's just not as much interrogation involved in a DUI. They typically will ask you things like, how much have you had to drink? What did you have to drink? Where are you coming from? Things like that, that would implicate Miranda. And then one of the questions they like to ask is, on a scale of 1 to 10, how impaired are you? Well, I mean, if you give a low number, that's seen as, well, you're too impaired to know. And if you give a high number, then it can be implicating to you. But those types of things are more likely when the Miranda issue arises.
So, Mark, you have worked in vice and narcotics, and I'm guessing that some of those suspects were on occasion impaired that you were dealing with. So, what are the parameters for interrogations when you are dealing with somebody who is intoxicated?
I mean, if they're to the point where they can't talk, I mean, there's no need to even bother talking to them at that point. I mean, there are times that you have people that you engage, whether it be a traffic stop or another crime, that they're almost incoherent or their eyes are rolling back in their head or whatever. It doesn't do any good for law enforcement to try and get that statement out of them at that point, because it's probably going to get challenged, and it should be. You're trying to look for other indicators and other witnesses if it's not a DUI and it's a case to corroborate maybe or find out or tie to whatever that person may or may not know. People you're interviewing that may be inebriated or impaired in some way, you're going to independently corroborate with somebody else. You're not going to solely rely on that, and you shouldn't. As far as DUIs go, I started in law enforcement in 1979, so there were no cameras. There were no dash cameras. There were no body cameras. We base everything on observations. What's the initial observation is how they're driving. That's the reason why you pull them over. So you're starting to take a thread, and you're trying to tie it all together. You engage the individual, and you smell the alcohol on them, or maybe not, but they're somehow impaired. First, make sure they're not medically, there's something wrong right away, because that happens a lot. And nowadays, people, unfortunately, medicines do strange things to people. Even though they're prescribed it, they may have over-medicated themselves. They may have mixed medicine with alcohol. They may have had 1 or 2 drinks, but they've taken it with a Xanax or whatever. Now they could be impaired. So these are the things you have to take into consideration. We would have to document things thoroughly, all right? And again, you're not going to get to a Miranda situation until it looks like you're going to put this person and take them into custody. There's times I've stopped people, and I've let them go. They're not impaired. They may have had something to drink. Admittedly, they may have said, I've had a drink, or I've had 1 or 2 drinks. Doesn't necessarily mean I'm putting them in jail.
If you're just joining us, we are talking about questioning suspects who are under the influence, and we want to hear from you. Do you think it's appropriate? Do you think that it's fair game? Call us at 904-549-2937, or you can email comments and questions to firstcoastconnect@wjct.org. Jacqueline, you begin with an example of someone who is impaired and crashes a car with a blood alcohol level of 0.291, which is nearly 3 times the legal limit. This person would be slurring and having trouble standing in your example. Is everything he says considered legally admissible in court?
In the particular case that you're referring to, that is what the court decided. I believe in that case, the court initially said that it wasn't admissible, but an appeals court said that it was. So it went back down. So obviously everything is decided on a case-by-case basis. There are going to be cases where somebody might end up successfully arguing that what they said should not be admissible, but it very frequently is deemed to be admissible.
Susan Cohen, what is the case law predominantly on this issue? And have you made these kind of arguments in court?
The It boils down to it's one of these totality of the circumstances situations. And so what the court's going to look at is everything that happened. Was it more coercive? Did they appear to understand? Did they say they understood? There's a lot of things, having worked within the criminal justice system for a very long time, there are a lot of legal fictions, if you will. And so particularly in a DUI, because what a jury has to find that somebody is guilty of DUI is that their normal faculties are impaired. And normal faculties are defined in the jury instructions, among other things, is their ability to make judgment and to do mental tasks, which would both relate directly to your ability to knowingly and understandingly waive your rights under Miranda. So it would appear that those would be two things that just would not be able to be reconcilable. But I mean, over the years, we've made attempts to raise that issue, but it always is a very difficult one from a legal standpoint for the reasons like she's indicated, that a lot of the case law is, well, they seem to understand that it wasn't overly coercive. They didn't ask for all these factors that go into making the decision. And so sometimes it almost looks like it's form over substance. As long as you do all the right things and you say all the right things, then it's going to be admissible. And it is a difficult argument to make.
Difficult because of how it's received by jurors, or just difficult legally?
Well, generally, you're going to make that argument to the judge in a pretrial motion to keep the statement out. And like I said, especially in a DUI, although you can make it the argument my client was too impaired in a pretrial motion, it's a little different than standing in front of a jury. The argument in front of a jury is always going to be a difficult one in terms of a DUI because, again, you don't want to get up there and argue that your client was too impaired to waive their rights, but they were safe to drive. So but it would certainly be a factor in another kind of criminal case that certainly might have greater weight in front of a jury who understands and can maybe be made to understand that this person was just saying things because they were impaired and they just wanted to say what they thought somebody wanted to hear. They're less able to make those decisions. They're less able to understand the ramifications of waiving their rights. And that's why I say it's going to be a very different argument in a DUI case versus a case where impairment is not an issue before the jury.
Jacqueline, I want to ask you a little bit about the way that you conducted this study. You had to actually bring in some student volunteers, or perhaps they were compensated, I don't know, but bringing them in and some of them had to get intoxicated. I kind of guess maybe that's not the tallest task at FIU, to get someone to come and volunteer to come drink, for scientific purposes. But how do you manage that? I mean, it is an unusual circumstance where you're bringing people in and asking them to drink to the point of intoxication.
Yeah, there are not that many labs that do this kind of work, and I understand why. It's actually very complicated work to do. As you can probably imagine, there are a lot of hoops we have to jump through from an ethical point of view to make sure that people can participate safely. One of those limitations that's placed on us, which I have no concerns with, I wouldn't want to be pushing any lines, but we, for example, are not allowed to try to get anybody more intoxicated than a 0.08 level. So that's one consideration when interpreting the results of our studies, is we're talking about people who are at kind of the legal limit for driving. You can reasonably expect that most effects will be larger as you get people more intoxicated. But in terms of our study, we have to have people go through a very extensive medical screening before they can participate. We ask them all kinds of things about their medical history, the potential for pregnancy, what medications they may be on, what their drinking history is. So all kinds of factors, all kinds of ways to end up volunteering for the study but not actually being able to participate.
And
But assuming you make it through,
yeah.
then yes, you're either randomly assigned to drink to the point of, again, it's a special formula based on your weight and sex to get you a dose to get you ideally to the zero point zero 0.08 level, or some people are randomly assigned to not drink any alcohol. And we also had a placebo group in all of our studies where we tell them that they're going to be drinking, and we take some efforts to convince them that that's happening, but they in fact are not getting any alcohol.
But to be clear, you're not allowed to, for reasons of ethics or just policy there at the university, you're not allowed to have people drink to a point that probably many people who are stopped for DUI or people who are intoxicated under interrogation would be at. Is that correct?
That is correct. Yes, there are some studies, not that I've personally conducted, but that are in the research literature where they've done field studies. So instead of doing what we do and bringing people to a controlled laboratory environment, they go out to bars and ask people to participate in some form of study, maybe a memory test or something like that. And that does allow you to capture those higher levels of intoxication because you aren't imposing that level on them. They've self-selected and chosen to drink to that point.
And Susan, just in your experience, how common is it that someone is in a case that you're involved with a say a point oh 0.08 as opposed to a higher level of intoxication?
I would say that the substantial majority are not an '08. Most of them are higher. It may not be, not all of them are a lot higher, but the and let me put it this way, because sometimes with these instruments, it's really hard to tell. I've been involved in DUI either as a prosecutor or a defense attorney for many, many, many years. And years ago, I remember if somebody blew a .20 or above, they were taken to the hospital. Now it is not unusual to have somebody with a .2 over a .2. So you're seeing higher numbers. I don't know that that's a correlation that people are drinking more or just the measurements that are being made, but that is a significant difference that I've seen. And so the majority of the cases that we have are not a .08. I mean, we still have those. We have some that are below a .08, but there's a substantial number of cases where they're substantially higher than that.
If you're just joining us, we are talking about research into the impact that intoxication can have on someone's ability to understand their situation or to waive their Miranda rights, and also just how it impacts someone in a situation as a witness or a defendant. You can join our conversation. You can call us at 904-549-2937. You can email firstcoastconnect@wjct.org, or you can tag us on social media. We have an email from Mark. He says, people who drive under the influence should consider how uncomfortable the legal entanglement becomes when they get a DUI. Furthermore, they should consider the social and occupational fallout. No question, it has an enormous impact on people's lives, Susan.
That's correct. And I don't disagree with anything that this gentleman has just said. And that's one of the things we address with all our clients is we're going to try to help in terms of the legal issues. And obviously, you don't want somebody's life completely destroyed going forward in their ability to maintain a livelihood and do the things they need to do. But at the same time, that they need to accept responsibility for making sure that never happens again, because it's just as dangerous for me for them to be on the street and for themselves as it is for anybody else. But the issue of the Miranda, when you talk about the protection of legal rights, what makes it so difficult is some cases are more a situation where you feel sorry for someone, you feel that they should be more protected, and other cases it's hard to feel sorry for people. But when you're dealing with constitutional rights and whether or not somebody is voluntarily waiving and the law and how that should be handled, you have to step back and understand that the protection of one person's rights protects all of us, and that some people who may have been coerced in confessions, as we've talked about, may not have been guilty. Some people who did not have their rights respected could be us, our children, our neighbors, people we care about. and people who we have more sympathy for. But you can't pick and choose. This person deserves to have their rights respected and this person doesn't. And that's why it's really a more general discussion and a more general concern as opposed to whether a particular individual deserves it. And that's why our system doesn't, and it is not supposed to make those individual decisions based on who the individual is. It's supposed to be made on the facts of each case.
Mark, I want to ask you in terms of questioning someone who's involved in a case, either as a defendant, primarily, I guess, as a defendant, if there isn't a little bit of a self-fulfilling circumstance. I mean, there's been some research that shows that interrogations tend to follow the belief of the interrogator, and that if they believe that someone's guilty, they will tend to be more accusatory in their tone and in their demeanor, and that can lead to false confessions. Um, and so the question is, if somebody is giving tells that Jacqueline's research has kind of shown that maybe they're doing something suspicious, raises a suspicion in the interrogator, does that kind of become a problem in terms of maintaining their impartiality when they're looking at a case?
Yeah, it does, of course. You have to keep in mind that when you're interviewing somebody, right, and this is somebody you're interviewing, not interrogating, right? You're wanting to know what happened. You want to know the truth, right? Sometimes you get led down that path a little bit just by what they're saying, and then all of a sudden your questioning starts changing towards that. You got to keep that in mind when you're interviewing somebody. Now, when you're interrogating somebody, you're looking for their culpability. You're wanting them to admit their guilt, right? So, yeah, you can start leading in that direction. You got to be mindful of that, especially if they're impaired. I mean, if I'm Mirandizing somebody, I'm probably going to incarcerate that person. I'm going to take them into custody. I've seen enough that I feel comfortable charging that individual with something, right? Whatever they say afterwards. In fact, I can tell you there's plenty of times when I've had people in the backseat of my car and I'm just like, do yourself a favor, don't say anything else to me. It might be better that you don't talk, right? Now, my car back then had an audio or video capability. Cameras are a game changer. Body cameras, dash cameras, audio recordings in cars. They're usually not advantageous for the person that's being interrogated / interviewed. I mean, that's the telling sign of it. A lot of times it's unsolicited. They just start talking, and you're like, don't talk. I don't want you to talk. And this happens. I'm sure you can agree with that.
Yeah.
It's not in their best interest.
Mm-hmm. I want to ask you, Jacqueline, about the indicators of guilt or perhaps behavior that can trigger additional suspicion. What is it that research has shown in terms of whether people who are intoxicated have those kinds of tells?
So that's a great question because there's very little research out there at all on that question in terms of intoxicated people specifically. There's research on just people in general and the behaviors that many people, including law enforcement, are typically trained to look for. That a lot of times is going to be behavioral cues. So the big one you often hear is things like just generally appearing nervous, gaze aversion, fidgeting, things like that. But you can also have situations where it's the exact opposite that raises suspicions. If someone appears not nervous or not emotional, anytime their response doesn't seem to match what you would expect it to be, given whatever situation they're in, that can be enough to raise some eyebrows. And so that's one of the reasons that as soon as somebody starts engaging at all, they're creating a situation where they might do or say something inadvertently that would create a higher belief in guilt on the part of the person they're talking to.
We should say that we did reach out to both the 4th and the 7th state attorney's offices to see if they wanted to weigh in on this issue. We also reached out to the Jacksonville Sheriff's Office, and they all declined primarily because of having so many cases pending on this topic. They just didn't feel like they could do so safely. But I want to ask you, Mark, I mean, there's some people that, might say, oh, this makes a suspect more vulnerable to questioning or perhaps understanding what they're up against. But some people might view alcohol as kind of a truth serum. Maybe they're more likely to tell you honestly what happened as opposed to otherwise.
They could. Yeah, they very well could. But then again, they could make it more than what it is. I mean, one of my questions were, especially on the DUI, is how many drinks have you had tonight? All right. So everybody always has number two.
Two.
I
Two
can't
beers.
tell you. Two is always like there. And then you're looking at them, you're like, okay, this person's 5 foot, 100 pounds maybe, or my size, which is a lot bit more than 100 pounds, and I'm a foot taller. Two may not do that. Two may do something else. But again, going back to the conversation with that individual, you know that it's more than two already. Now, do you want to keep talking to them at that point, or are you just making your observations? So, I mean, yeah, people, it can cut either way. It can go towards them making themselves more culpable in that sense, or they could, for a fact that it's not. You know what I mean? That the alcohol definitely is a contributing factor. And if I may add something to the study that you did here, is that the people that are drinking, their freedom's not involved here. I mean, the study's good, don't get me wrong, but at the same time, when your freedom's involved and you're in a situation where you're pulled over on the side of the road, you have the police there with you, a lot more is at stake. And now you have a different set of circumstances that are presented in front of you. Your car, if you're taken into custody, is going to be impounded. It's going to be inventoried. So if there's anything in there other than that that's contraband, it's probably going to go towards you anyway, whether you say anything or not. So, I mean, these things all get taken into consideration at the time. So these people are trying to defend themselves on the side of the road, I've seen them happen a number of times. Then I've also seen them hurt themselves on the side of the road, too. It just depends.
Jacqueline, I want to ask you about one famous case because we haven't really talked about how impairment impacts juvenile defendants or juvenile suspects. But there's a case that's sort of known as the Fairbanks Four. It involved a 17-year-old who had a blood alcohol level of 0.158, and he confessed to a murder. Can you tell us a little bit about that case?
Well, I am not an expert in that case, but I have heard of it. I am familiar with that particular example. And what I can say is it's unfortunately not that shocking to hear that an intoxicated juvenile was questioned. There was one study that was conducted where they surveyed juveniles who were in a detention center, and about 40% of them said that they had been questioned while intoxicated at some point. So it's certainly not against kind of the standard practice, at least not at the time this was conducted about 10 years ago, for that to happen. And we already know that juveniles are at risk in an interrogation context for reasons that are probably intuitive to many people, but juveniles are not great at thinking about the long-term consequences of their decisions. They tend to make more impulsive decisions, focus on the short term, and in an interrogation context, focusing on the short term is typically going to entail thinking to myself, what can I do to get out of this situation that I am not happy to be in?
Right.
And so typically confessing is how you make the interrogation stop. Whereas if you continue to deny, they're going to continue to ask you questions.
And Susan, in this case, the 17-year-old that was questioned, he confessed after 11 hours of interrogation. And in the end, 4 innocent men were convicted and spent, more than a decade in prison. They were later exonerated, but it was in part, they believe, his intoxication that led to that false confession.
Well, I think she's right. When you're dealing with juveniles, that's a whole different ballgame. Their brains are just not the same as an adult brain. Under the law, you're allowed to interrogate a juvenile, and it's the limitations are not as strong as some people might think they would be for a kid. So I think it's hard to equate that. The fact that they were impaired obviously would have a significant impact on even lowering their inhibitions. I mean, that's part of their problem is they have no way of recognizing long-term effect or really processing things the same way you do as an adult. And so being impaired is going to obviously impact that. But also an 11-hour interrogation, number one, your level of impairment is going to obviously decrease over an 11-hour period. And I would think that particularly in a situation like that, 11 hours of interrogation is going to be the most significant aspect of why that was a problem, even if he was impaired at the beginning. So I think that's a difficult connect to make in terms of the trying to equate that to the adult situation and the impaired adult, because that's a whole different discussion, I think, a whole different circumstance.
With the juvenile too, I mean, you want a guardian or a parent there during that process. I mean, law enforcement should do that. If they're not doing it, there's something not good right there, right up front. You want, if there's not one available, then right away, then hold off. You know what I mean? Until there is somebody that's looking out for the best interest of that individual, especially a juvenile. Because as you said, they're going to say some things that they probably shouldn't be saying, whether they're impaired or not. Even at some point, they're just not prepared to go through this. It's true. They probably want to get it over with, and they may admit to something that they didn't do. So it's prudent to have somebody there that's looking out for them. And it's no different than having an attorney once it gets to that point.
And Jacqueline, we've just got about 30 seconds left, but can you tell us what reaction you've gotten so far to this study and what's next for you in terms of research?
Yeah, so we're really excited about this study because it was the only study that has ever done anything remotely like this, actually put intoxicated people in an interrogation situation where they actually had something to lose, and we were able to look at both how guilty and innocent people responded. So it's really a noteworthy study in that sense.